Pranam, the die is cast. The updation battle lines at the Supreme Court are drawn. The out-of-court settlement option has left the building. The final tactical and strategic maneuvers, mental rehearsal, and the compilation of evidence supporting final arguments are done. So tomorrow, Thursday, January 15, both sides in the updation battle will come out swinging.
I'm Priya Chakraborty and my colleague is Nisha Bhattacharya. Yes, tomorrow at the Supreme Court, before the bench, no quarter will be given. Bank retirees, the petitioners who have waited for 30 years and banks who risks 30 years audit of the corpus will come out fighting for total victory.
Welcome to the January 15 deep dive. Today, as battles are joined at the Supreme Court before the Honorable Mr. Justice Vikram Nath and the Honorable Mr. Justice Sandeep. Mehta, we're getting into something that is, it's complex, it's bureaucratic, but it's also profoundly human.
Absolutely. We're talking about the decades-long legal fight over pension updation for millions of retirees from India's public sector banks or PSBs.
And this isn't just about some minor accounting change, is it?
Not at all. We have a whole stack of documents here, minutes, regulations, legal filings, and they all point to this fundamental conflict.
A conflict between what exactly?
Between a promise that was made back in the early 90s, one that seemed to guarantee pension rights, and the formal regulation that was written later, which
There's a witched, right?
which left that promise out entirely.
So our mission today is to guide you through this paper trail and to highlight the challenge before the justices at the Supreme Court during today's MC Singla final disposal hearing.
The paper trail, including meeting minutes and the like, not least specific aspects of the Constitution, will come to play a major part in today's hearing.
Critically, we want to understand what was promised, where the gap is, and what India's Supreme Court is now being asked to decide.
And the stakes are just immense. This affects the financial stability, really the dignity of lakhs of many senior citizens. The MC Singla case has also taken on new meaning since the new Chief Justice's decree for courts to prioritize cases relating to super seniors 80 years or older.
Okay, so before we dive in, let's get the key term on the table: pension updation. What does that actually mean in the context of today's hearing?
Simply put, it means that when current bank employees get a pay rise, the pension for those who've already retired also gets adjusted. It's meant to link their retirement income to current living standards.
Without it, inflation just eats away at bank retirees' pension.
It erodes it. The updation appeal, either at the Delhi High Court or the High Court of Punjab and Haryana, once received objective evidence that retirees' income had lost 80% of its value since at least 2008. And, our source material shows that even when a scheme doesn't explicitly define how to do this, there are still established ways.
Right? There are alternatives. It's not like they have to invent something from scratch.
Exactly. The Supreme Court, in its decision, could follow an existing model like the one the Reserve Bank of India uses, or it could use actuarial methods like stage-to-stage fitment. The point is, solutions exist.
But the banks have just insisted the legal scheme is silent on updation, therefore they don't have to do anything.
That's the crux of it. And to understand that silence, we really have to go back to the 90s, to where this all began.
The initial push for this came from the RBI, the Reserve Bank of India.
That's right. The RBI introduced its own pension scheme with the Reserve Bank of India Pension Regulations 1990, which came into force on November 1, 1990. That was the template. But here's the really crucial detail for what comes later.
What's that?
That initial RBI scheme, it didn't actually have a provision for updation itself.
Oh. So the foundation they were building on was, in a way, already incomplete.
Yes. So then in October 29, 1993, you have the Indian Banks Association, the IBA and the unions. They reach a memorandum of understanding, an MOU.
And what did that MOU say?
It said they would introduce a pension scheme for the PSBs on the lines of the RBI pension scheme. They even set up a committee to draft the provisions, including updation, by the end of 93.
Okay, so the intent was there, but then we get to the most critical document in this entire saga, the minutes signed in March 1994.
This is the absolute linchpin of the whole case. These weren't just meeting notes. They were signed under the Industrial Disputes Act, ID Act 1947.
Which gives them what? Real legal weight.
Immense legal weight. They're treated as binding agreements, almost like law, until they're replaced by a specific piece of legislation.
And what did those binding minutes say about pension updation?
This is the exact clause being argued in the Supreme Court today, Clause 4.2. It says, and I'm quoting here, formula for updating pension should be on the lines of the same given in the RBI pension scheme. Any change therein should be introduced only after mutual agreement.
Wait, so it's not ambiguous at all. It's a direct, non-negotiable link to the RBI scheme.
That was the promise. So, based on that promise, employees had to make a huge choice.
We had to opt in, right? And to do that, they had to give something up.
They had to surrender their entire contributory provident fund, the CPF, all their accrued savings based on the trust that this promise in the minutes would be honored.
That's a massive act of faith in that document.
It is. But then when the formal regulation, the Bank Pension Scheme of 1995 or BPS 1995, actually came out,
The promise wasn't there.
a huge gap appeared. Clause 35 of the new regulation did have an updation formula, but only for a tiny group.
Really? Surely not.
People who retired before 1992, 83. For everyone else, for all the people retiring from then on, the regulation was completely silent on updation.
So the core promise from those legally binding 1994 minutes just vanished for most people? How did that happen? Why didn't the unions object right there and then?
That's probably the most painful part of this whole history. The best explanation is that they were tracking the RBI scheme so closely.
And the RBI scheme at that exact moment also didn't have an updation clause.
Exactly. So they saw it as consistent. It wasn't that the promise was intentionally broken, it seems, but more that it got lost in the regulatory translation, an assumption that things would just follow the RBI's lead.
And that single failure, that assumption in 95, is the direct cause of this crisis today.
It is, and that brings us to the modern fight, to the Supreme Court case listed for today.
This all started with a case filed by a retired employee, MC Singla.
Yes, his case was dismissed in the Punjab High Court, but the appeal, which we now call the MC Singla case, is what's been pending in the Supreme Court.
For nearly 10 years. Just think about that. For someone who retired in the 90s, 10 years is a huge portion of their remaining life.
And tragically, the original petitioner, MC Singla himself, has passed away while the case was pending.
So now pensioner associations have had to step in to keep the appeal alive. It just shows you the real human cost of these delays.
And all this time, the official positions haven't budged. The IBA filed an affidavit in the Supreme Court with a very simple defense.
Let me guess, it's not in the 995 rule book.
That's it. There is no provision for updation in the formal text of BPS 1998. The text is silent. Therefore, the obligation doesn't exist.
What about the other players, the unions, the government?
Well, the unions are often perceived as being surprisingly casual about it. They've tended to categorize updation as a residual issue during wage talks.
Residual? It seems pretty central.
You'd think so. And the government of India has basically taken a hands-off approach. Despite pressure from MPs and others, their line is that this is something for the IBA and the unions to sort out.
So the retirees are completely stuck. The IBA denies the provision, and the groups that could force a settlement are on the sidelines.
Which is why the entire weight of this history now rests on the Supreme Court's interpretation of a few key legal ideas.
Okay, so let's break those down. What's the first major point the court has to decide?
It's the direct clash. The binding 1994 ID Act minutes versus the 1995 regulation. Which document wins when they flatly contradict each other?
And for the retirees, their strongest argument here is something called the Doctrine of Estoppel. Can you explain that in simple terms?
Estoppel is basically a principle of fairness. It says you can't go back on your word if you made a promise that someone else relied on, and acting on that promise cost them something.
So the banks promised an RBI-like pension. The employees relied on it by giving up their savings.
Exactly. The argument is the banks are now estopped. They are legally prevented from arguing that the promise doesn't exist just because they left it out of their own paperwork later.
If you're enjoying this podcast, please like, share, comment, and subscribe.
The YouTube algorithm promotes our podcasts when you subscribe and like. Thank you.
That feels like a very powerful moral and legal argument. But there was also an amendment later in 2003 that complicates things.
It does. The 2003 amendment to that same clause, 35(1), added a new layer of ambiguity. It now says basic and additional pension, wherever applicable, shall be updated as per the formula.
Wherever applicable. Those are just weasel words, aren't they?
They certainly are. The court has to figure out what that was meant to do. Was it just formalizing the old rule for pre 92 retirees, or was it a quiet acknowledgement that a broader right to updation was supposed to exist all along?
It's a battle over two words.
It really is. But, the legal framework itself actually provides a potential way out if the court finds the whole thing is just too ambiguous.
How so?
Clause 56 of the BPS 1995 itself says that in case of doubt, you can refer to the Central Civil Service Pension Rules.
And do those rules provide for updation?
Yes, they do. So if the Supreme Court decides the bank's rules are just fatally flawed, they have clear path to say, okay, just use the central government's rules.
All right, so we've covered the contract under the regulations, but the next argument is the big one, the one that ties this whole thing to the Union of India Constitution.
Yes, the DS Nakara case from 1982. This is a foundational judgment. It established that a pension is neither a charity nor a bounty. It's a fundamental right. Property, wages earned but deferred to a later date. This is Article 300A of the Constitution. And crucially, it banned discrimination among pensioners based only on their date of retirement.
This sounds like it applies perfectly here. If you deny updation to someone who retired in 1995, but people who retired later might get it, isn't that literally discrimination by retirement date?
That is the strongest constitutional argument. It invokes Article 14, the right to equality. Is the bank creating two classes of pensioners based on nothing more than timing? The Nakara judgment said you absolutely can't do that.
If the court agrees with that, this goes way beyond just interpreting a contract.
It becomes a constitutional mandate.
And the final thread that ties all this together is, well, it's the RBI itself. The whole promise was to be on the lines of the RBI scheme.
And in March 2019, the RBI finally granted pension updation to its own retirees.
So that forces the question, was the 93 promise a static snapshot of the RBI scheme as it was then, flaws and all?
Or was it a dynamic promise, a commitment to ensure that PSB retirees would keep pace with their RBI counterparts as the scheme evolved? That's what the Supreme Court must decide or whenever final disposal is.
And there's even a precedent for this kind of thinking, isn't there? Looking at the nature of the work itself?
There is. The argument is that the duties of bank retirees at the RBI and the PSBs are essentially one and the same. We saw this with the regional rural bank employees. They were given pension benefits because their duties were deemed similar to PSBs. The court can look past the regulatory details to the actual work being done.
When you lay it all out, it's just a story of a regulatory mistake that has snowballed into this massive decade-long crisis.
Absolutely. The Supreme Court is weighing the silent text of that 1995 regulation against two enormous legal principles, the explicit promise from the 1994 minutes and the constitutional command of equality from the DS Nakara judgment.
So as you, the listener, follow this case, what's the one thing to really watch for? What does this all hinge on?
At the end of the day, it all comes down to how the court interprets that DS Nakara principle. If they decide that these PSB retirees who gave up their life savings based on a promise are being fundamentally discriminated against, how far will that ripple?
A finding of unconstitutional discrimination won't just grant updation in this one case. It could force the creation of a whole new permanently dynamic pension standard for public sector employees across the board. That's what's truly hanging in the balance after all these years.
Thank you for watching. Please like, comment, share and subscribe. Aapke liye alvida.